Hello, everyone. Going to be talking about prohibitions and their exceptions, and here's a couple of examples of prohibited acts within wilderness area, and both of these things are taking place in wilderness, and there are exceptions that apply. We'll get into some discussion about those. Now, Ralph Swain on Monday went over the Wilderness Act, and he did briefly go over this topic here, these parts of the Wilderness Act. I'm not going to do a bunch of repeat of his, but I'm going to go a bit deeper into this subject and go into some detail about the extent of these prohibitions and their exceptions. So again, there's me. I'm been at the Carhart Center for about 6 years now. I was a wilderness program lead at the New Mexico State Office prior to coming to the Carhart Center, located in Missoula, Montana. So first of all, with prohibitions, early wilderness protection really didn't have much in the way of provisions. Going back into the 1920s with Forest Service L regs, the first formal protection of wilderness areas administratively, the guidelines for those areas did not have much in the way of prohibited acts within wilderness. And then the very first congressional wilderness legislation, which relates to the Park Service with the Everglades and Cape Hatteras in the 1930s, also did not have prohibitions. In fact, when the discussion with the Everglades was going on, they purposely determined that they wanted this to be the wilderness parts of the enabling law there to be positive, to be something that doesn't include prohibitions. And it didn't really work out because a lot of development occurred with that. We need to, positive is good, but we need to have some explanation of what can occur in the area in order to really protect that area from becoming developed. And furthermore, the courts, when they are looking at these issues, they're going to apply the prohibitions in most cases related to any kind of litigation on this topic. So when we got to the Wilderness Act, prohibitions were seen as a very important part of the Wilderness Act and included. There are 10 prohibited acts identified in the Wilderness Act, and I'm not going to go through all of these specifically because you did that with Ralph on Monday, but I will highlight a few of the ones that questions often come up related to. First of all, the use of motorized equipment. There is an exception for some motorized equipment within wilderness. Small handheld portable equipment where there's only negligible force is allowed in wilderness, so cameras. And there are a list in most of the agency's regulations of examples of what falls within that exception, including electric shavers, which I've often looked at and just kind of scratched my head over is, why does that make the list? How important is that? I don't personally think of going and shaving when I'm in a wilderness area, but there it is, it's on the list. Landing of aircraft is another one that needs a little bit more attention. Yes, drones are aircraft according to FAA regulations, and they cannot be landed, taken off, or operated from within a wilderness area. And paragliders are also considered aircraft. And so that's why paragliders are prohibited from taking off and landing within wilderness as well. Now, sometimes folks will look at situations like, well, what if I long line some equipment out of a wilderness or into, or maybe I'll just hover the helicopter and hop out. Is that considered landing? Yes. By regulation, any dropping off or picking up equipment by aircraft is considered a landing, and so therefore prohibited. Mechanical transport is one of the more tricky prohibitions, and the definition of mechanical transport has been the subject of some controversy and disagreement. But what we need to do is go back to the common definitions of what mechanical is, what transport is, and that's what our regulations are based upon, is those common definitions, which means that wheelbarrows, bicycles in particular, hang gliders, etc., are prohibited within a wilderness area. And the reason for that is because of going back to these definitions. We have interrelated parts of simple machines and can cover some distance. So when we have this combination of effects, we have a mechanical transport that's prohibited within the wilderness area. What's not prohibited, and these are called out specifically in policy and regulation, are rafts, skis, winches, riggings.
Yeah. So like through Chase, my bank, yeah, they have like.
We have someone off of mute. Okay, I'll continue on. And so riggings for trail work are not prohibited, and the reason is to go back to these definitions. We are not, with those types of transport covering large distances or including multiple interrelated parts of simple machines. Also not prohibited are wheelchairs, including electric wheelchairs within wilderness. And the reason for that is because of the Americans with Disabilities Act, which states that nothing in the Wilderness Act is to be construed as prohibiting a wheelchair. Now, wheelchair has a definition. Wheelchair is something that's used by a person with a disability, first of all. It's also designed solely for mobility impaired people. So a Segway would not be considered a wheelchair because it is not designed for mobility impaired people. It's designed for the general public. And then furthermore, it must be suitable for indoor pedestrian uses. So a internal combustion engine power source is not suitable indoors and so cannot be considered a wheelchair under the Americans with Disabilities Act. Structures, just touch on this briefly. A structure is defined as something that is left behind in wilderness and intended for human occupation. So a tent would be considered for human occupation, but we don't leave those behind. We take them with us when we leave the wilderness. If someone were to set up a camp, however, with a bunch of tents, that would be prohibited, or set up a yurt. Everything else that is made by humans and left behind are considered installations. So if they're not designed for occupation by people. And this is another one of those areas where there's a bit of controversy and a bit of complexity. There's quite a few things that can fit into that definition. They can be temporary or permanent. Size doesn't matter, large or small, including that on the top right there, that's very small monitoring device. Stationary or mobile, manufactured materials or natural materials, and then pre or post wilderness designation. So the Wilderness Act does not specify that things existing prior to an area's designation are grandfathered or allowed. They can only be in wilderness if they meet one of the exceptions. So we have all of these prohibitions, but with most prohibitions, there's going to be some exceptions, and the Wilderness Act is no exception to that. And there are 4 categories of exceptions, and we will go through all of these. I'll list them off first. The first category is except as specifically provided for in this act. So we'll see special provisions like landing of aircraft. Subject to existing private rights. Some wilderness areas will have private subsurface mineral ownership, and the owner has a right to develop those. We might have situations where there are buildings that are privately owned within a wilderness area, and those rights will continue to be recognized. This is probably our biggest area of special or exceptions to the prohibitions that we address routinely in management, and that is as necessary to meet minimum requirements for the purpose of this act, which includes the ability to rescue people, and it might include installing an artificial water in order to replace natural water that has been lost due to human activity. And then other legislation. Talked about the Americans with Disabilities Act, but there are other laws that allow for things that are otherwise prohibited as well. So we'll go through all of these, starting with except as specifically provided for in this act, which comes out of 4C of the Wilderness Act, and points us to the special provisions section of the act, which is located in section 4D. It also points us to other places in the act, but the majority of these provisions occur in section 4D. So we'll take a look through all of these special provisions that are found in the Wilderness Act itself. The use of aircraft and motorboats where they have been established may continue. It doesn't say that they have to continue, but they may continue subject to the Secretary's restrictions. And then measures to control fire, insects, and diseases may occur in wilderness, and that also is subject to what the Secretary deems desirable. And so what the Secretary deems desirable is captured in agency policy, which is not that anything can go with the control of fire, insects, or diseases, but we employ the minimum requirement principles in managing fire. The second and third special provisions deal with mineral issues, with prospecting and new mineral development. This provision only applies to the BLM and the Forest Service. Furthermore, the mineral development provision expired at the end of 1983, so no new mineral activity can occur in wilderness areas starting in 1984. But prospecting can continue. Prospecting has to be done in a manner that's consistent with preserving the area's wilderness character, so no prohibited uses. And then the odd thing is once someone finds something by prospecting, they cannot stake a claim. They cannot take possession of that material. So not a lot of reason to do that. The fourth provision includes two parts. The first part deals with establishing water reservoirs. So this gives the president the authority to place a reservoir and other infrastructure related to that power production and water retention in wilderness. It's never been implemented, but that authority does exist. And the second half of the provision deals with the grazing of livestock. So where livestock grazing was established prior to wilderness designation, it's permitted to continue, but it is subject to reasonable regulations. This provision only applies to the Forest Service and the BLM. The fifth provision is related to the boundary waters canoe area. So this is just one wilderness area managed by the Forest Service dealing with motorboat use, but this provision was actually repealed back in the 70s. So we move on to commercial services. So commercial enterprises are prohibited. One of the prohibited uses that is identified in section 4C, but here is the exception for a subset of commercial enterprises, which is services such as guiding and outfitting, which can occur in wilderness as long as it is proper for realizing the recreational or other wilderness purposes, which refers us back to section 4B of the Act, and only to the extent necessary. State water laws are the sixth provision, and then the last provision deals with the jurisdiction of wildlife between the states and the federal government. That provision only applies to the Forest Service and the BLM. So I'm going to take a little bit of a deeper dive into these two because they are a little harder to understand and frequently misapplied. So starting with the provision for water rights. Nothing in this act shall constitute an express or implied claim or denial on the part of the federal government as to exemption from state water laws. Kind of a mouthful. I find this to be probably the most difficult sentence in the Wilderness Act to understand. Got to read it a number of times, but the big focus here is that the federal government is neither claiming or denying anything related to water rights. And so what this means is that the status quo remains. The status quo is that when the federal government reserves land, it reserves sufficient water to fulfill the purpose of the reservation. So in this case here, the reservation of land is wilderness, and so sufficient water to fulfill the preservation of wilderness character is implied. The wildlife jurisdiction provision is a little bit more difficult to understand. We often come into this with particular baggage, so to speak, on how to interpret state management of wildlife. And that tends to kind of flavor our interpretation of this particular provision. But what we're going to do is we're going to take that language, and Congress has added this word here, authority. They've taken out the reference to the national forests and replaced it with some additional provisions that appear stronger than the original, or than the provision in the Wilderness Act, and apply to the Fish and Wildlife Service, to the wildlife refuge system. This is a provision within the enabling law for the National Wildlife Refuge System. So this appears to be a stronger provision than what occurs in the Wilderness Act. And there was a situation where the state wanted to do some elk management within a refuge, and the Fish and Wildlife Service said that they weren't going to allow that activity to occur. The state said, well, you have to because of this provision right here. Well, this went to court, and it made its way up to the 10th Circuit. And this is what the 10th Circuit said about this situation. Federal management and regulation of federal wildlife refuges preempts state management and regulation of such refuges to the extent the two actually conflict. So if there's a conflict between the Fish and Wildlife Service's purposes and the state's objectives are going to recede. And then about that specific provision in the Refuge System Act, they said this: we find highly unlikely that Congress would carefully craft the substantive provisions of the enabling law for Fish and Wildlife Service refuge, and then essentially nullify those provisions and regulations with a single sentence. So you would ask then, well, how does this apply to the Wilderness Act? You know, it looks like that we have similar language and probably similar outcomes would occur. And indeed that is the case. And in a district court, a similar situation came up related to state desire to manage wildlife, and the state said very similar things. It was a different state, but pointing to the special provision in the Wilderness Act, the state said that they do not need approval from the federal agency because of that provision. So pointing to the earlier 10th Circuit case, the court said, while this language preserves the state's right to manage wildlife in the wilderness area, Congress did not mean to eviscerate the primacy of federal authority over the wilderness area. And the state must obtain approval from the Forest Service before undertaking a project in the wilderness area. Okay, so in summary, what does this all mean? How do we interpret that, that special provision in the Wilderness Act? It did not enlarge or diminish the state jurisdiction. The state has the authority to manage wildlife. That continues up to the point of a conflict, an actual conflict with the Wilderness Act. And so where the state intends activities in conflict with preserving wilderness character, that must be approved by the federal agency. And we're going to go through a minimum requirement analysis to make those types of determinations. Okay, so moving out of the special provisions section and into access to state and private lands. It is in a different section of the Wilderness Act, but it could have just easily been included in the special provisions section. Where the state or privately owned lands are completely surrounded by wilderness, we are to provide adequate access. And what adequate access means is the access that was occurring at the time of wilderness designation. Same type, mode of transportation, and travel routes. The Fish and Wildlife, the Forest Service and the BLM, the Fish and Wildlife Service and the National Park Service only provide access through pre-existing valid existing rights of ways. And then section B is addressing valid occupancies wholly within wilderness. Valid occupancies are things like mining claims. It might be a pipeline, could be a radio repeater. Any facilities like that fall into this category. And for these, we provide customary access, which is access commensurate with the situation at hand. So most of these decisions are going to be made through a minimum requirements analysis process on how to implement the special provisions. But some of the provisions are unique and they have some unique processes involved with them, such as commercial services. The next category is existing private rights, next category of exceptions. And so existing rights are typically things like mining, valid mining claims, private mineral estate, or rights of ways that were granted prior to wilderness designation, such as a road right of way or a pipeline right of way, something of that nature. So where those rights have been explicitly identified, such as through a right of way grant, we're going to follow the terms and conditions of those rights of way grants in determining the extent of that right and that exception. Where they're not explicit, then we will use the MRDG to assure that we both satisfy the right while also minimizing impacts to the wilderness area. And so selecting alternatives that might provide less of an impact than perhaps the alternative that the owner of that right would like to use. So we use that process to make sure that we've selected the correct, or I should say the least impacting alternative. So moving over to the minimum requirements exception, which comes out of section 4C of the Wilderness Act, necessary to meet minimum requirements for the purpose of the act. So this exception is applied to 8 of the 10. It's not applied to commercial enterprises or permanent roads, but the other 8 of the 10 prohibited uses can be authorized in a wilderness area if they are the minimum necessary for the purpose of that act. So we need to take a close look at, well, what is the purpose of the act? That is section 4C points us to the purpose of the act. This is not referring to section 4B, public purposes of recreational, scenic, scientific, educational, or conservation or historic use. The purpose of the act is identified in this court case, Wilderness Watch versus Creechbaum, where they identify again that section 4C language, except as necessary to meet minimum requirements for the administration of the area for the purpose. And then they replace of this act with where they want to point us to for the purpose, which is found in section 2A, securing the benefits of an enduring wilderness. So the purpose of wilderness is to protect wilderness. Why is this distinction important? Because prohibited uses are allowed for the purpose of wilderness, that is to preserve wilderness character. So we can apply or use any of those prohibited actions if they are necessary for preserving wilderness character. And that analysis occurs again in the minimum requirement decision guide, which will point you to identifying the determination of necessity for action in wilderness by identifying if there is a need to preserve one of the qualities of wilderness character. And if so, we can consider using prohibited uses. So other legislation is the next category, and this really splits into two different subsections. One is enabling legislation. So all but our original 54 wilderness areas will have its own wilderness enabling law, and there might be provisions within those laws. And then there are unrelated legislative requirements or mandates outside of wilderness related legislation that might apply as well. We'll talk about these both in detail. First of all, special provisions in enabling legislation have increased over time. There seems to be more and more of them. And so what's important to know is that we have to read for a given wilderness area, the Wilderness Act and the enabling legislation in concert with each other to understand the full list of special provisions that might exist. Back with the Wilderness Act in the 88th Congress, there were only a handful that we just went over, but ANILCA hit a spike, ANILCA designating the majority of the wilderness in the system, 50% of it roughly in Alaska, included a lot of special provisions. And then later on, special provisions have been pretty substantial. In the 114th Congress, quite a few have been included. Dingle Act is our most recent wilderness enabling legislation, and it's a little tamer. So these things are important to look at. There are four different categories I've split things into related to special provisions in enabling law. One is that there's some additional to the Wilderness Act standard group that we keep seeing repeated time and again. There are specific allowances in specific wilderness areas, and there is a tendency for there to be repetition of special provisions in enabling laws with the Wilderness Act. And these present some interesting challenges, which we'll get into an example of here shortly. And then finally, there's some withdrawal of special provisions that have occurred with the Wilderness Act. So first, looking at the additional standard group, we see routinely a provision that allows for military overflights, a provision that prohibits buffer zones, and then a provision that allows for any acquisitions of private lands or non-federal lands within a wilderness area to become a part of the wilderness upon acquisition. So those are repeated pretty frequently in legislation. We're seeing some other ones kind of coming into the scene too that are more common related to monitoring for climate monitoring type issues, flooding in particular. And then special allowances to a specific wilderness area. Some unique things will show up in individual laws. This one on the top here allows for the development of a system of new trails. What's interesting is that it calls for consideration for those trails to be located near resorts that surround the wilderness area. And then on the bottom there is a special provision for a new water line to be constructed in wilderness. So You never know what you might find in your enabling law. Reiteration of the Wilderness Act. Here is an example of a special provision that addresses commercial services, which is already addressed in the Wilderness Act. And it says that they are authorized. Most of the language is identical to the Wilderness Act, except for they are authorized, whereas the Wilderness Act itself says may be performed. So that can lead you to a question as to, what does this mean? Is this different? Was Congress intending to do something more permissive perhaps, or maybe more restrictive related to commercial services in this case? In this particular situation, the provision goes on to say in accordance with the Wilderness Act. And so when we know, or we're pretty sure in this particular case, that this is unnecessarily provided in this enabling law. It's not going to be different than what occurs in the Wilderness Act. But just a cautionary word is that these can become some head scratchers on other types of uses or other types of activities, and might require some consultation with your legal counsel to figure out if this reiterated part of the Wilderness Act has been reiterated in a different manner, requiring a different outcome than what the Wilderness Act provides for. And then finally, withdrawal of special provisions from the Wilderness Act, primarily with this one right here, the presidential authority to establish a new water facility within the wilderness area. Increasingly, we've been seeing that provision taken out of for a given wilderness area in its enabling law. On the topic of water rights, we frequently see no Federal Reserve water rights being claimed as another type of example of this rescinding or taking away of what the Wilderness Act special provision might have allowed for. So I'm going to move now over into unrelated legislation. What I mean by this is that these laws here weren't written with a intent or a direction towards the Wilderness Act. But what we need to understand and need to know is, how do we implement these laws in conjunction with the Wilderness Act? And these are just a few examples. There's a long list of federal laws, but this is an example of some that come up more frequently. So I'll just pose the question, does the Wilderness Act supplant all other laws? And I'll answer the question as well. The answer is no. All applicable laws must be satisfied. So when the courts are looking at two different laws, they're always going to try to, that address the same area, they're always going to try to harmonize those statutes so that they can be read in concert without any conflicts. But conflicts do arise. And so the rules of statutory construction resolve the conflict. So all applicable laws must be satisfied, but, and there's a big but here, is that we need to understand what other laws actually require. So all federal laws don't require that they be implemented at the same level. So to understand how to blend these laws and how to understand which one might take prominence over another, we're going to apply the principles of the standard principles of conflict preemption for statutes. And these four in particular are the ones of most interest to us. A specific law is going to take precedence over a general provision. An outcome-oriented law is going to take precedence over a procedural-oriented law. Shall versus may, these are two real key words that we need to focus in on when we're reading statutes. Statutes written in terms of shall require an outcome. Statutes written in terms of may provide options, but don't necessarily provide a specific outcome in most cases. And then the question of federal law versus state law. So first, we'll spend a little bit of time looking at this question between the specific and the general provision. And as an example of specific and general provisions, we're going to take a look at Section 4A of the Wilderness Act, which tells us that the Wilderness Act is within and supplemental to the agency establishing purposes. So our organic legislation within each of the agencies. So the first thing that we need to do before we go any further into evaluation of how to apply this is to understand what the term within and supplemental means. In particular, supplemental. Oftentimes we look at this and think that supplemental kind of means secondary. Looking at the dictionary, that's not the case. First of all, within means that the Wilderness Act is inside of those agency establishing statutes. We're putting the Wilderness Act inside, and it completes those organic laws. It makes up for a deficiency. So the Wilderness Act is a pretty important piece of legislation overall within the purposes of each of our agencies. So we need to read that 4A provision in concert with Section 4B of the Wilderness Act, which tells us wilderness shall be managed for such other purposes for which it may have been established as also to preserve its wilderness character. So other purposes that come out of a whole variety of places, including our enabling laws, I should say our organic legislations, our agency enabling laws. Those are going to be implemented insofar as to preserve the area's wilderness character. Got to read these two in concert. So going back to the courts to help us understand how to combine and apply these conditions. In this court here stated that a long established rule of statutory construction is that where there is a specific provision that governs an issue, it takes superiority over any general provision. This rule allows the NPS and put any of the four agencies in there to administer this wilderness for other purposes only insofar as to also preserve its wilderness character. So that last sentence there comes right out of Section 4B of the Wilderness Act. So what laws are they talking about here? The specific provision for this case is the Wilderness Act. And the general provision, where there was actually several, but one of them is the Organic Act of 1916, so the Park Services Enabling Law. So any of those provisions that come out of those general statutes can be applied, but they have to be applied in a way that preserves the area's wilderness character. The next category is outcome versus procedural law. And so an example of a procedural law identified by this court is the National Historic Preservation Act, which doesn't create new substantive preservationist obligations. There are many ways to comply with the National Historic Preservation Act. And the court says that this is overwhelmingly a procedural law, not a outcome-oriented law, as compared to the Wilderness Act, which emphasizes outcome, wilderness preservation, over procedure, and as such is as close to a purist manifesto as may be found in the area of environmental law. So these laws, we're going to apply them in a manner that also preserves the area's wilderness character. Shall versus may, again, these are important words to look for. The Wilderness Act is written in terms of shall. This is the mandate out of Section 4B of the Wilderness Act. Each agency administering any area designated as wilderness shall be responsible for preserving the wilderness character of the area. It's not a option, it's a requirement. This is a provision out of a wilderness enabling law And it tells us that in accordance with House Report 101-405, the state may continue to use aircraft, including helicopters, to do a bunch of wildlife-related work. So this law is written in terms of may. Now, frequently, when we look at this at first face, we look at it and think, okay, the state is being given opportunity to use aircraft, and we don't have a role in that decision. This does not say that the state is being given the authority at their discretion to use aircraft. It's saying that aircraft use might be one of the opportunities. And Congress is using these words intentionally and specifically for a reason. And we can see that by the fact that, yes, the state may use aircraft, but they can use aircraft as long as it's in accordance with House Report 101-405. So what does 101-405 say? All management activities within wilderness will be done without motor vehicles unless such use is the minimum necessary. So that provision points us back to a minimum requirement analysis. It doesn't point us to use of aircraft in all situations. All right, and then the final preemption principle to apply to our wilderness situation would be federal law versus state law, which is pretty straightforward. Federal legislation necessarily overrides conflicting state laws under the supremacy clause, and this is a Supreme Court decision here. So if the state were to write a law that says hunters can use ATVs in accessing wilderness areas, that law would not be applied in a wilderness area because it would be preempted by the federal law because it conflicts. So this stuff can get tricky. You need to oftentimes seek advice. So the first place to go is to consult with your wilderness lead for your agency, your regional lead. And in most cases, they have been exposed to many of the situations that come up and can help walk you through there. But if there's something unique, then you may need to consult legal counsel within your agency to further understand that. So we'll look at a couple of other laws that actually do require some kind of activity within wilderness area. Starting with the Endangered Species Act.
Hey James, I'm going to give you a real quick 5-minute warning on the session overall. 5 minutes.
Okay. All right. Thank you. I'm sorry I wasn't watching my clock correctly, but I'm just about to wrap up here. So the Endangered Species Act uses the term shall. This is an act that's pretty easy to implement in concert with the Wilderness Act because both are intending to preserve species. Wilderness Act will also address or point us towards preserving the area's wilderness character in the activities we take to implement that. And so we're going to go through a minimum requirement analysis to determine what that is. A law that's a little bit different that provides some, or a provision, I should say, that provides some allowance for things that aren't compatible with preserving wilderness character would be the grazing provision. This is not discretionary. Where we had grazing shall be allowed to be permitted to continue. And then the Congressional Grazing Guidelines gives us some sideboards regarding protecting the range resource from deterioration and not intensively managing for livestock increases. So we continue grazing, we prevent deterioration of the range resource. We don't necessarily preserve wilderness character to its fullest extent. And we use a rule of practical necessity in making those decisions. And then finally, on the farthest extreme, the Real ID Act allows the Secretary of Homeland Security to waive all environmental laws. And where they do, the Wilderness Act no longer applies, even though it's a wilderness area, but we can seek the opportunity for mitigation. Why is this important? Because you are going to be asked these questions in the minimum requirement analysis. So understanding these principles is important to answering these two questions, whether action is necessary related to other laws. So in summary, we have these 10 prohibitions in the Wilderness Act, but we have 4 exceptions, except as specifically provided for in the Act, the special provisions subject to existing rights, necessary to meet minimum requirements for the purpose of the Act, and the purpose of the Act would be to secure the benefits, to preserve wilderness character, and then other legislation might apply. There aren't a lot of situations where other legislation does. We went over a few of them, but sometimes they do. So with that, I will open up to questions.
Hey, James, great job. Thank you. I actually learned quite a bit in that presentation. So we had about 5 questions and we've only got about 2 minutes. What I'm going to do is I've asked folks to drop their email in the chat if they want us to follow up, or we'll record that. And we also, you and I can work on the questions afterwards. And when we post the recording, they can find the recording and see what the answers are. I'm just going to start from the top since I don't want to get out of order. The first one was, do you know how many wilderness areas have airstrips by any chance? I didn't know the answer to that one.
Yeah, I don't know the answer to it either. I can name off a few. The Bob Marshall has them. The Mexican Mountain Wilderness in Utah has one. The Selway Bitterroot has them, and the Frank Church does as well. I'm drawing a little bit of a blank on that based upon those might be on private inholdings, but I don't have a total number. That would be an interesting stat.
Okay, great. And then we had a question on, have you been involved or seen any discussions around the new action track chair? I've actually had it pop up down here in the South one time. It's a new tracked accessibility device that's being marketed specifically that it's usable where you can go anywhere on foot travel. Have you seen anything with that one yet?
Well, I've seen a little bit. The basic rule is if you can use it indoors and it's a person who needs that chair for mobility, then it can be used in the wilderness area. Gotcha.
Yeah, and there's a lot of information around that. So Sam, I think you can, if you have more questions, feel free to let us know. I think one of your old friends, Peter, asked a question about the 4D1 and quote established prior to being airstrips, motorboats, that type of stuff. I have a similar question. Maybe that's something I can ask you and we can provide in the recording when we do that. The question was, so we can work on that one. There was a lot of discussion and some folks tried to help answer the question regarding minerals. It said minerals development was no longer allowed as of the 80s. Was that for federal minerals? Are development of outstanding and reserve minerals still allowed? And there was some follow-up that there's no new mineral development allowed in wilderness.
Right, that's the correct answer. So if there is an existing valid mining claim, that can continue to be developed and so forth, but no new mineral activity is allowed.
Gotcha.
New meaning a brand new claim, not new activity on the claim, on an existing valid claim.
So here's one that I've been working on myself. Would a designated campsite be considered a structure or an installation? Does it depend on what is placed on the ground to designate it? Do you know of any examples of MRDGs on designating campsites?
Yeah, great question. If there is a tent pad that is constructed on the designated site, that would be considered to be a structure, and so a prohibited use. But of course, there's a lot of other stuff going on with that particular situation, in that there is also an impact to the area's wilderness character as far as unconfined recreation. outstanding opportunities. So all of that needs to be considered and unpacked in determining what is the least impact to wilderness character. Presumably you're doing this because there was some impact to wilderness character to begin with that would require consideration of a designated campsite. So all of that needs to be weighed out to identify what's the least impact to wilderness character in the given situation for a variety of alternatives. But that's certainly one of the questions that needs to be considered, is that if you're putting in a tent pad, you're putting in a structure.
Great. All right, well, we've run a couple minutes long, and there's probably another session on this Zoom account here in about 8 minutes. So James, thank you for this great presentation. Thank you everyone for joining, and we'll be seeing you all soon. Thanks again. Have a good day.
All right. Thanks a lot. Bye-bye.